Mark Reckless.
The Home Secretary has to convince the Supreme Court that her case raises an arguable point of law of general public importance. Should she not therefore put the key constitutional question, is Strasbourg entitled to move the goalposts, or is it our Supreme Court that has the last word?
I have to say to my honourable friend, and he and I have had a number of discussions and a number of questions and answers on this particular issue, not least at the Home Affairs Select Committee last week. At the heart of his point is the question about the relationship between Britain and the European Court of Human Rights. And I've said it in answer to other questions already, that I believe that we should be looking at all the options, and that should include leaving the jurisdiction of the court altogether. But we are currently signatories to the Convention, and we have to abide by its rulings, and I believe governments have to abide by the law. And even if we were to ignore the court and put him on a plane regardless of the court's ruling, and I don't believe in practice we would be able to do so, we would risk the courts ordering us to bring Qatada back to Britain and pay him compensation. But worse than that, as soon as we start ignoring our international obligations under international law, we wouldn't be able to rely on other countries' obligations to us under international law. And I think that would jeopardise our national security, and I think it would indeed jeopardise many other deportation cases. And I fully understand the frustrations of my honourable friend and others who share his view. But our options are to operate within the law, and I believe we should operate within the law or change the law. And I've been clear about the need for us to look at that. And I have to say to him, dare I say it, I think urging the government to break the law is, dare I describe it as a rather reckless step.